I think we're ready to get started. I want to thank you all for joining us on our webinar. We are going to be discussing here today the Families First Coronavirus Response Act and additional programs that may be applicable. I'm joined here today by my colleagues at Murray, Plum & Murray. We have Ali Tozier and Sage Friedman, who are both in the employment and corporations sections of our law firm. And I hope that today we are going to be able to answer a lot of your questions on the FFCRA, as the act is known. We have opened up the line previously to questions that many of you submitted ahead of time, which we appreciate. And also we have been dealing, as I'm sure you can imagine, with a lot of our clients, employers, and employees throughout this period. And so we have designed our presentation to answer some of those questions at the outset. We have a couple questions that we've already addressed at the end of the presentation. And then hopefully, if there's time, we'll be able to take some of your questions on a Q&A front via the Zoom application at the end. You'll see that we have a PowerPoint presentation. Because of all of you registering and providing your email address, we are going to be able to email that PowerPoint presentation to you at the end of this webinar. It will also be available on our website at mpmlaw.com. And we're going to be uploading this video in its entirety to YouTube and be on our website. Again, hopefully this will answer a lot of your questions. As you all know, this is a very fast moving set of regulations and statutes and processes that change daily. Just yesterday, the Department of Labor issued some more regulation and guidance and frequently asked questions. So, and we've updated this program in response to that, but we expect more information to be coming out daily and by the end of the week. So I've already introduced our wonderful panelists. And why don't we go ahead and get started? The Families First Coronavirus Response Act, or FFCRA, requires employers with fewer than 500 employees to provide Emergency Paid Sick Leave Act, Emergency Paid Sick Leave, or EPSL, and Emergency Family and Medical Leave, or EFMLEA. Both the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act are parts of FFCRA. The acts do overlap, which you're going to hear a lot about in this webinar, but they are separate acts. Because acronyms can be so difficult to follow, we're going to attempt throughout this webinar to differentiate between the two acts by calling them sick leave and family leave. You will hear that at times we're going to be talking about the Pre-Emergency Family Leave Act, in other words, the Pre-FFCRA Family Leave Act, the regular FMLA. When we do that, we will differentiate between that. But as a general matter, when we refer to family leave and sick leave, we mean those leaves as under FFCRA. FFCRA applies April 1st through December 31st. As you all know, today is April 1st. Employers with 500 or more employees are encouraged to provide the same leave. They are not going to be reimbursed at this point. A question that has come to me a lot, and that again we are going to talk about additionally in this webinar, is what happens to employees that have already been terminated or furloughed before today, that is before April 1. And correspondingly, employees who after April 1 get terminated or furloughed. In other words, they are no longer working at all. Employees who you may have already terminated or furloughed prior to today are not eligible for leave under the Act. Going forward, if you need to terminate or furlough employees, again, they are not entitled to leave. That can be a little bit more confusing in terms of when you can furlough or close, but I want to be clear that anybody that has already been terminated or furloughed is not eligible for leave under this Act, and they are eligible for unemployment. Now, Ali, I'm going to turn to you. Can you tell us what notice employers are required to give their employees?
Sorry, I was muted for a second. Hi, everybody. Thank you for being here today. I'm Allie, as Stacy said. And yes, employers need to inform their employees of the new law. The government has specifically put that burden on employers to make sure that the employees understand what their rights are, and has provided a free poster that is downloadable. If you go to the link right there in the slide that, again, you'll get a copy of, you can just download it, and you can post it in a place where people can see. But we advise that you also email it out to your employees or even text it to them to make sure everybody gets a copy.
Allie, do you think if an employer's business is closed, it is sufficient to post that in the business?
No, it is not, because as you can imagine, the whole point of it is that the employees can read it, and they won't be able to read it if they're not there. So please make sure that you get it to them in some way.
So the first provision, we're going to talk of the FFCRA Act. Again, there's two different leaves that are part of FFCRA, and that is the Emergency Paid Sick Leave Act, or EPSLA, and that's in Division E of the FFCRA regulations. As a general matter, that requires that eligible employers provide eligible employees with 2 weeks of employee paid sick leave for a total of 10 days or 80 hours for full-time employees for any of the qualifying 6 reasons. And employers are responsible for payment under the Act, but can get tax credits to recoup funds used to pay the sick leave. Again, we'll be talking about that more later. Now I'm going to turn to Sage and ask him, Sage, which employers are required to comply with this Act?
So all employers with fewer than 500 employees must comply, with the possible exception that for some very specific, very narrow reasons, there is a small business exemption. It applies to sick leave, but only to one of the reasons, that being the childcare reason. And we'll explain that a little more shortly. The other big exemption is that it doesn't apply to healthcare workers and emergency workers at the discretion of their employer. And given the situation, most employers in that situation will probably choose to be exempt.
Now, Allie, what about employees? Which employees are eligible for emergency paid sick leave?
So all employees are eligible, and so if your employee was working as of yesterday, a day, then they would be eligible, and that includes temporary and seasonal employees. And it is important to distinguish your employees between full-time and part-time, and full-time employees are eligible for 80 hours or 2 weeks of sick leave.
And what about part-time employees? How much leave are they, paid sick leave, are they eligible for?
So to determine how much leave for sick leave a part-time employee gets, you have to look at the average that person works in 2 weeks, and that's the amount that they would get for sick leave.
So, for example, if you have a part-time worker who normally works 3 days a week, say Monday, Wednesday, Friday, and she is eligible for paid sick leave, how many days is she eligible to get paid for sick leave under this Act?
Well, in that example, you said the employee works 3 days, so in one week. So in 2 weeks, she normally works 6 days, so she would only get 6 days of paid sick leave under this Act.
Okay. Now, of course, we're going to go into it later, but as we talked about, certain provisions, one provision of the sick leave and the emergency family leave do overlap. So she may be eligible for more leave under the Family Leave Act, but we're just talking about with the Sick Leave Act, correct?
Correct. Yeah, we're breaking it up for purposes of clarity right now.
And I know, just to clarify, but this is a question that's frequently been asked of me, is those part-time employees who only work a few days a week already, we're going to get to how you calculate the normal days of the week and hours of the week. But again, they can't get extended paid sick leave to get 80 hours. They are only eligible for the hours they would normally work in a 2-week period, correct?
That's correct, exactly. And we'll talk a little bit further on in this presentation, but it's important for employers to comply with this in order to get back the money from the government that they spend. They have to follow the rules.
Now we're going to turn back to Sage. Sage, we've talked about the employers who are eligible under this act and the employees. Tell us about the qualifying conditions for the Paid Sick Leave Act.
So as we mentioned earlier, there are 6 reasons why someone can take the sick leave benefit, 6 different qualifying conditions. They're really easily dealt with in 2 groups. The first 3 deal with the impact of COVID-19 individually on the employee. So that means they're under a local quarantine or isolation order, or they've been advised by their doctor to self-quarantine because they're showing symptoms or they've been in contact with someone who is. Or if they're potentially seeking a diagnosis, it doesn't have to be diagnosed, just to be clear, given the trouble with testing. As long as they are showing symptoms and looking to be diagnosed, that is a good enough reason. The second,
and I'm going to stop you there just because I think that's an important point to clarify, Sage. Thank you. So if you have an employee who is symptomatic, but as you said, unable to either get to a doctor or get to a test, which we've heard, I think all heard in the news, can be hard to come by, and in fact aren't given to everybody, they could still qualify for the paid sick leave under this act, right?
Yes, and given the trouble with testing, the general watchword is to believe people when they tell you that they're experiencing symptoms or that their doctor has told them to stay home. We'll cover documentation more later. But the general thought is to give people the benefit of the doubt here. Okay. The second 3 reasons, the second 3 qualifying conditions relate to your employees caring for others and their situation caused by COVID-19. So that could be that a member of their household has been self-quarantined, or they're taking care of a loved one. But one of the big ones to highlight is number 5. Number 5 is that your employee needs to take leave in order to care for a child because their school or daycare is closed and there's no other child care available. This is something that I imagine is affecting a lot of people's employees, and they're struggling to make it work. This is something to pay close attention to, because it's gonna play out until the schools reopen.
And Sage, number 5, and that is the employee taking leave for child-related reasons. That is where we're going to have the greatest, in fact, the overlap with the Emergency Family Leave Act, right?
Yes, because unlike for sick leave, for family leave, that's the only reason you can take it.
So we're going to get into this overlap in depth, but this is really important for people to appreciate is there's 2 separate acts. There's separate, we're going to get into pay structures. So remember that under paid sick leave, a reason for paid sick leave is needing to be out due to child care related issues, which is the reason that you could also qualify for the Emergency Family Leave Act. So keep that overlap in mind. So again, we talked about payment. Tell us about how much people get paid. Does it depend on the reason that they are taking, again, we're under paid sick leave. Does it depend on the reason that they are taking the sick leave?
Yes, it does. So there are 2 different rate structures. For the first 3 reasons, the ones that relate to the employee's individual needs, them being sick or them being under a quarantine order, they get up to this amount. So it's supposed to be 100% of their pay, up to a daily limit of $511 and a total limit across the 2 weeks of $5,110.
And then what about if an employee is taking sick leave because they're caring for someone else?
So in that scenario, they go down to 2/3 of their pay, up to a much lower maximum of $200 a day, or $2,000 over the 2-week period.
Now, what about employees who are entitled to paid sick leave? What happens if those employees are terminated?
I'll answer this one. So if an employee is qualified under one of those 6 reasons for sick leave, but let's take an example. Let's say that they're qualified because they need to take care of a family member who has COVID-19, but they only need 5 days out of the 2 weeks. Let's say they're a full-time employee, so they get 2 weeks, but they only take 5 days, and then they're no longer needed after day 5 to take care of their family member. Then they still get to bank the rest of that. So they get to bank, say, another 5 days, because they have 10 total. And so if another qualifying reason arises before December 31st, which is when this act no longer applies, then they could take their remaining 5 days.
And to clarify, as of now, the FFCRA goes until December 31st, 2020. Of course, we don't know at this point whether or not it could be extended.
Correct.
So Allie, now I'm going to ask you about other forms of leave. Can employees force or require, can employers force or require their employees to take other leave before they get paid under the FFCRA Act?
No, the employer cannot force the employee to take other leave. Now, the employee might have other leave that was there in existence before this act went into place, and the employee can opt to take that leave, but the employer cannot force it.
So for example, as Sage just said, for paid sick leave, if you are taking sick leave because of one of the first 3, or we'll call them individual qualifying conditions, sick leave that affects you personally, you're eligible to get paid up to 100% to a daily maximum. If you're taking sick leave for childcare related reasons, you're only eligible to get paid for 2/3 of your salary up to a $200 maximum. So it's possible if an employee and an employer agree, they could get paid more than that based on their own accrued sick leave. Is that right?
Yeah, so if the employee is out for sick leave because of one of the reasons that relate to someone else, or taking care of someone else, so they're only getting 2/3 of their pay and they want 100% of their pay, then the employer can choose to give that employee the last third of the pay, especially if the employee already had leave that had accrued before this went into place. But it's important for the employer to know that the employer won't get reimbursed for that last third in that case.
So as you can imagine, like other forms of statutory leave, the leave under FFCRA has strong anti-retaliation provisions. And so it's important that you keep that in mind. This is difficult and fast moving, and certainly no employer would intentionally retaliate against an employee for taking this leave. But we want to be sure that you are considering that and sort of considering appearances of that, and make sure that no employee is penalized for taking this leave, which they are eligible for. I think in particular, this could come up with employees who need or request additional unpaid leave for COVID-19 reasons. This could come up with sick leave, but also with respect under the Family Leave Act, as employers may just run out of leave, but still for COVID-19 reasons need to be out. So we want to be sure that you may not be able to give them that unpaid leave and still have them maintain their job security, but you may be able to. And so just make sure that you're thinking ahead of time for your business related reasons why that may or may not be the case, because we wouldn't want there to be an appearance of, oh, you have treated this one employee differently because she happened to take leave while others did not. So now we're going to turn to the corresponding act, which is the Emergency Family and Medical Leave Expansion Act, or the EFMLEA. Again, throughout the webinar, we're really referring to the Expanded Family Leave Act for this. The Expanded Family Leave Act is a subset, sort of regular FMLA. But many of you listening may be employers who, because of the size of your business, the number of employees you have, who normally are not required to give benefits under the FMLA. You are still required to give benefits under the Emergency Family and Medical Leave Expansion Act. There is a provision that we'll talk to you about at length this morning about getting an exemption for being a small business under 50. But at the outset, everybody is considered to be included in this, whether or not you normally provide FMLA. And like the Paid Sick Act, employers are responsible for payments under these acts, but can get tax credits to recoup the losses, which we are going to talk about. For those of you who normally work within the framework of the FMLA, we want to be clear that the Emergency Family Leave Act is much more expansive than the FMLA. First of all, the FMLA does not apply to employers with less than 50 employees. The Expanded Medical Leave Act does. Again, except for this small business exemption, that isn't an automatic exemption. That's an application with specific requirements that we will get to. The FMLA, for those of you who know the FMLA, only applies to employees who have worked for a specified number of hours and have been employed for over a year. The Emergency Family Leave Act applies to all employers with fewer than 500 employees, except for that exemption that you can apply for, we'll talk about. But an even bigger difference might be that it applies to employees who have been employed for at least 30 days. So that is a much more narrow set of employees. The other thing to keep in mind while we're contrasting and comparing the two acts, that is the Emergency Paid Leave Act and the Emergency Family Leave Act, the Paid Leave Act applies to all employees who have been employed for even just one day. The Family Medical Leave Act is for employees who have worked for 30 days. So, Sage, I'm going to turn to you. What is the qualifying event for employees under the Expanded Family Medical Leave Act?
So this is a parallel to the to number 5 from the sick leave. An employee has to be unable to work or telework due to a school or daycare closure related to COVID-19. So the concept being that they're caring for their child and are unable to work.
Okay, and we've put in bold, and I want to emphasize, we have the or telework. So if an employee has been and is able to work from home, is he or she eligible under the Expanded Family Medical Leave Act?
No, if they can telework, they're not eligible. Of course, as many of us have discovered, teleworking from home while having other people around is more complicated than we might have thought. So some employees may discover that despite their best efforts, they do actually have to take leave to care for their children. But if they, the can telework is not just a could they, it's can they.
Right, is it actually functioning? And we're going to talk again later on about intermittent leave, but we'll let you know that intermittent leave, or is available under both of these acts with some provisions to the same. Now I'm going to jump in here with a question that I have got, and that is, these provisions apply for people who have to care for their children due to daycare or school related closures. So we've had a lot of questions: is what if my employee's daughter is 16, and do I still have to give her the time off to care for that child compared to somebody who has a child who's 2 years old? And I think the regulations aren't specifically clear on that. They do refer to child, and so I think you need to read that expansively. I don't think anybody in the government or here wants this act to be read that teenagers get to sort of run around unsupervised, but toddlers need care. So I think that a college age student, it's likely that this wouldn't have to apply, but I think anybody under the age of 18 certainly, and through high school, those employees still could take leave to care for their children, even if it might be a different type of care than they would need to for a toddler. So now we're going to turn to the payment structure of the Family Medical Leave Act. And this should look familiar compared to a little bit of what we saw under the Paid Sick Leave Act. So Sage, tell us about the payment under the Family Medical Leave Act.
So the Family Medical Leave Act is divided into two chunks. So the first 2 weeks of it are considered unpaid. However, that can be taken in conjunction with some of the other leaves. So we'll come back to that. For the remaining 10 weeks, it pays at the same pay structure as if you're taking reason number 5 for sick leave, in that it's 2/3 of your regular pay, up to $2,000 a day, and in this case, up to $10,000 across that 10-week period. You can, as an employer, allow, but you're not required to allow the employer to use other paid time during that first 10 days. They can just take it unpaid if they want to. If they have PTO built up, they could use that. Alternatively, this overlaps with the sick leave. So they could start by taking 2 weeks of sick leave. That counts for the first 2 weeks. And then they could take 10 more weeks getting paid under the family leave.
So, and to remind everyone that the payment structure under the Sick Leave Act for the piece you get paid for, if you're taking that sick leave because of childcare related reasons, you only get the 2/3 of regular pay up to $200 a day. So if somebody wants to get those 2 weeks paid, which you assume most employees would want that, and then 10 weeks paid, it is going to all be at the same rate. Is that right?
If they're doing it through these FFCRA leave benefits. Again, though, they could use, if you have a normal internal sick leave policy where they accrue days, they could use those days. They could use vacation days. Depending on what programs you offer, the watchword is flexibility, but under the family leave portion of FFCRA, those first 2 weeks don't get paid for.
And then just to again clarify how much this overlaps in terms of total leave, we've talked here about how you could use paid sick leave for the first 2 weeks, family medical leave for the last 10 weeks, if you're taking leave to care for child-related issues, I should say. But then that leaves an additional 2 weeks under the Family Leave Act that you could also still take unpaid. So that could be a total of 14 weeks, 12 of which would be paid, 2 of which would be unpaid, but you would still have your protected status. Is that correct, Sage?
Yes, that is correct.
Right, Allie, now I'm going to turn to you to ask you about certain workers that may be exempt from, either the paid sick leave or the Family Leave Act. Can you tell us about that?
Yeah, sure. So Stacy mentioned this in the beginning about healthcare workers and emergency provider or emergency responders. Employers of those individuals can opt out of both the sick leave and the family leave requirements under FFCRA. And then for federal workers, not all federal workers get family leave. In fact, not many do, but they all do get sick leave.
So again, one of the things that you should consider if you are an employer who employs individuals who are in the healthcare industry is to really probably going to want to consult with counsel, really drill down on that. This exemption, I should say all positions related to FFCRA for healthcare providers are different than other types of healthcare exemptions. It is not necessarily the healthcare fields that allows their employees to be exempt. It really has to do with the actual position that the employee is taking. So for example, that your administrator or your HR person in a healthcare related field, you might not be able to, and actually probably won't be able to exempt that person from these regulations as a blanket matter. There may be other reasons why you can exempt that person. But so that is something that you should really consider and speak with counsel about if you want to take this exemption into account. So Allie, can you tell us how the hours are calculated for both the sick and the family emergency leave acts?
Yeah, so you need to look at hours when you're determining the rate of pay. So first of all, if you have a salary or full-time employee, you're just going to keep paying that person the normal rate that they usually get paid. So it would be either 100% of their salary or 2/3 of their salary if they're full-time and salaried. If you're dealing with hourly employees, exempt employees, then what you're going to do is you're going to first look to see if you have an agreement in place. If you have an agreement in place that discusses the hours, you're going to go by that agreement. But if there's no agreement in place, you're going to look at the last 6 months and take the average hours that that person worked in those last 6 months. If that person has worked fewer than 6 months, you would just take the average of the hours that have been worked.
So again, Allie, this is a change from those employers who are familiar with the FMLA, right? The FMLA has a calculation of looking back for a whole year, but under the emergency leave, you are only allowed to look back and average the previous 6 months. Is that right?
Yes, that's right.
Now, we talked previously about documentation. So Ali, tell us, I understand that we didn't have any information, but as of yesterday, the DOL has given us some information about what documentation can or is required. Can you tell us about that?
Yes, this is a hot topic for employers, as you can imagine, because everyone's wondering, what do I need to require from my employee in order to give them this paid leave, whether it be sick leave or family leave. And we just discovered that that employers do need to collect documents as much as they can collect, because that's going to matter when the employer is trying to get reimbursed. They're going to need to prove that that employee was subject to that leave. However, the exact documents that they need, it's unclear. So they've given some examples. The DOL has said, to save emails and to, if there's a school closure or a posting or a notice published, to save those documents to prove that this employee needed to take that leave. And so what we're advising as employment attorneys is to really just capture everything that you can possibly capture, meaning taking screenshots of text messages, saving them. You want to have an employee file for every employee that you have, and you want to be saving all of your communications regarding these leaves. And like Sage said earlier, you really want to take their word for it. If they say they have symptoms, you can ask for a doctor's note, and we suggest that you do ask for that. If you could say, can you send me an email that the doctor sent you, or a document that the doctor sent you advising you to self-quarantine, or talking about your symptoms, or the family member that you're saying has it. So you can request all of that, but we think you should give them the leave and then request it, and not kind of hold out on it until you get those documents.
Okay. And so, for example, I have kids in the public school system, and we have a sort of town-wide email from the superintendent saying that schools are closed until April 26th. So do I need to provide any more specific information, or is that public disclosure sufficient for my employer?
It's sufficient for your employer if it's readily available to the employer. Like for instance, there's a stay-at-home order now statewide, so the employer really should not be showing to the employee and asking the employee to give them a copy of that. The employer can just go print it off. So you want to realize that if you can get it yourself as the employer, whatever the document is that shows this qualifying event took place, then you want to do it yourself. But if it's something that the employee really needs to give you, then you should request it from the employee.
And that can be as simple as, oh, hey, your private daycare is closed. Could you just send me an email, forwarded from the owner of that daycare, just letting me know that they closed down? Is that right?
Yeah, that's right. And I'll add that, again, these are changing all the time in terms of what the government wants from employers and what they're really going to need. So, this could be updated later, but for now, just do your very best to collect as much as you can in terms of proof.
And err on the side of flexibility with your employees.
Yeah, they've said the word flexibility many, many times in these regulations. So the government really wants employers to work with their employees and not make it hard for them.
So one of the questions that comes up a lot is, of course, job protection, and what, if any, job protection applies to employees who take this leave under these two acts, or just one of the acts. And for those familiar with the FMLA, the job protection is the same as with the FMLA. For those of you who have not otherwise had to comply with the FMLA, the short answer is the employee is entitled to come back to her or his same job at the same conditions as before they took their leave. Again, there are going to be exemptions that apply. So for example, an employer with fewer than 25 employees who can show that the position held by the employee when the leave started doesn't exist anymore due to economic conditions or because of other changes in the operating conditions of the employer, can be exempt from putting that employee back in the exact same position with the exact same entitlements. And of course, given the economic hardship that this virus is having, this may be true for a lot of employers. But regardless, employers must first make reasonable efforts to put that employee back. So you've got to do your best to try to put that employee back where he or she was when they left before they took the leave. But if you can't, you have to be able to ensure you can justify the reason for that and make, basically get them as close as they can and kind of explain why that's not possible. Another thing that we want to reiterate, which I mentioned earlier, but that is this law is not retroactive. So any benefits you provided before April 1st, you're not eligible for tax credits. And I'm actually going to go back to job protection because, and we're going to talk about this later, but I think it's important to reiterate, is that this is for employees who are eligible and who take and who employers provide the leave under FFCRA. If you have an employee that you have previously furloughed or terminated or laid off, any of those terms, they're kind of interchangeable in this day and age with respect to COVID-19. That person is not entitled to job protection. That person comes back. People often think that furlough and usually assume and usually mean that furlough is going to mean that their employees are temporarily off. And then when they come back, they'll be back in the same position. And that is great for that to happen if it does happen, but you're not obligated to do that. And it may be that you have to bring employees back at different times, that the economic conditions of your business have changed. So when you bring them back, you do have to bring them back at fewer hours or a lower rate, as long as, of course, that's at least minimum wage. So we're differentiating here between job protection that the leave under FFCRA gives employees and just job protection that you as an employer are hoping to be able to provide, but that you are not committed to statutorily. So the next question we want to talk about is intermittent leave, and I briefly addressed this earlier. And there's sort of two caveats to intermittent leave. That is intermittent leave. The first one is intermittent leave while teleworking. Can employees who are teleworking take intermittent leave? The answer under both the Sick Leave and the Family Leave Act to that is yes. And we just put that you want to get that in writing. So it very well may be that to care for your child, which is the qualifying reason for family leave, as well as number 5 for sick leave, you can work, Monday, Wednesday, Friday, but Tuesday, Thursday, there's no one else to help you with your child. And so you have to not telework that day. So that is allowed under both of these provisions. Again, the employer and the employee have to agree. This isn't something that the employee can mandate, but it is certainly available and certainly might make sense in a lot of situations to do it. The same could be for half a day. I need the mornings to, my spouse and I are splitting mornings and afternoons. Again, if that's something that you agree to do, then you can go ahead and do that, assuming the employee is teleworking. There is a difference with intermittent leave for employees who are working at a work site. If an employee is taking family leave because they have to care for a child due to daycare-related reasons, then yes, they can do intermittent leave. So again, the same scenario could apply Monday, Wednesday, Friday, they're at the office, Tuesday, Thursday, they're home. Of course, Governor Mills has now, shut down the state basically for all businesses that aren't essential, but certainly if you're an essential business, this could apply. However, it is very different for an employee who wants to work intermittently or asked to work intermittently from a worksite job with respect to sick leave. If that person is asking for sick leave under the number 5 qualifying position, that is a child care related reason, then the same analysis applies as family leave, and sure, you can allow sick leave if you want. Although in that instance, it has to be taken in full day increments. So you come in Tuesday, Thursday, you're out Monday, Wednesday, Friday. You can't do the half days. However, if an employee is asking for intermittent leave for sick leave for any of the other reasons, which again are to care for or because they themselves are sick, you cannot take intermittent leave. Of course, if you think about it you cannot take intermittent leave from a work site. And of course, if you think about it intuitively, that makes sense. They don't want people who are exposed to the virus going home and coming back and going home to the work site. So that's just a difference. Again, that might be less applicable due to the Governor Mills' recent decision on only essential businesses being in effect, but it certainly could still apply. So keep those differences in mind. Now, Sage, we've talked a lot about the small business exemption, sort of leading up to this grand set of slides. Tell us about the small business exemption, who it applies to, how it applies. Tell us what you know.
So I just want to start with a caveat for everyone that this is an area where we have had a tremendous amount of interest, but where a lot is still unknown. We're expecting more guidance in the next few days. Indeed, it might very well post while we're in this webinar. But it's also a very narrow exemption. So please keep that in mind. It does not apply to all types, all business situations. This is very specific. So it may be available for very small businesses with less than 50 employees. It only applies to family leave and to sick leave for childcare related reasons. It is not an automatic exemption. You will have to apply for it. Of course, none of the paperwork is available yet, and we don't know what that process will be. But the fundamental concept is that the exemption will only be available if compliance with these FCRA benefits will jeopardize your business's viability, meaning it will likely close. So there are 3 reasons that have been articulated, but I think they are probably just sort of examples, and we should expect a few more. The first is if your business is going to be unprofitable because of these new and added expenses, and you'll have to close. The second is if the risk, this poses a risk to the viability of your business because you will be missing specific key people who you require to operate. So with specialized skills or knowledge or key responsibilities. And then finally, if it leaves you without a sufficient workforce such that you just can't operate, you could potentially be exempt there as well.
Now, Sage, what about documentation? Do we have any information on that yet?
Well, the one thing that the Department of Labor has been clear on is please don't send us anything yet. So we don't really know what kind of documentation will be required, but you'll need to prove the case that your business will be likely to close because of one of those reasons in this scenario. So that could include, you know, your profit and loss statement. That could include banking information. It could include a lot of things, but think about it as if you were trying to, you know, prove it to somebody that you can't shoulder this bill in a negotiation, and start gathering the evidence now. More information will be available on how this works soon.
Right, thanks. And this is going to require, you know, high-level analysis, right? I mean, we're going to need an officer, you know, CFO, CEO to sort of be starting to make this analysis and provide this information. And we do think that people should start doing that now, so that once the forms, you know, regulations are available, you're going to be able to jump on that. Is that right, Sage?
Exactly.
I'll just add something here, just because I think it's been recently clarified, because before people thought maybe this exemption was for any of the 6 reasons, and like Sage says, it's really just for childcare. So if you're an employer and you don't know whether your employees have children, you really need to find that out to even know if they would be taking this leave for childcare, because it doesn't apply if they could be taking it because they're sick.
In other words, the exemption doesn't apply, right? There is no exemption, small business exemption, for the paid sick leave provision of this act. So we've talked about this and paying and who's exempt and whether you can be exempt. Who's going to pay for it, Sage?
So ultimately, the government will be paying for these benefits. But of course, as employers, you're going to be fronting the bill and then getting reimbursed. But the government has implemented a system to provide as close to immediate relief as possible. So let's talk about it a little bit. Again, let's just recap how much money is involved. For sick leave, depending on the reason, it's either $511 a day or $200 a day. For family leave, it's up to $200 a day. That money will be reimbursed through payroll tax credits, a fully refundable payroll tax credit based on the actual cost of leave. So if you provide $2,000 worth of leave, that is what you will get back.
So, and Sage, you have some examples, is that right, about how this might work in effect?
Yeah, so the way the immediate money flows is that you'll be offsetting these costs against your payroll tax withholding obligations, including the employee's contribution that you're holding for them that you would normally deposit with the federal government after a payroll run. So the example here is you're paying $5,000 in sick leave expenses, and in that same transaction, that same payroll run, you're going to be depositing $8,000 in payroll taxes with the government. Well, under this, instead of depositing the full $8,000, you'll take back $5,000 for your leave expenses, and you'll only deposit $3,000.
So, Sage, what about if employers are spending more on these leave provisions than they put in their payroll tax withholdings? How does that work?
So it'll start the same way. They will take what they can out of the payroll withholdings, and then the IRS is going to be processing expedited refund requests. And of course, the forms involved in that process aren't clear yet, but the IRS has publicly committed to a 2-week processing window. Hopefully they can meet that. But here's our example again. Let's say you spent $10,000 on leave. You only had $8,000 in deposits. You'd keep the full $8,000, and you would apply for the refund for the $2,000, which would hopefully arrive in about 2 weeks.
Now, I want to be clear, to everybody that, we are not tax attorneys, we are not financial advisors. We are providing a very, high level, 20,000-foot view of some of these credits that are available. You certainly need to work with your own counsel, accountants, financial advisors about these credits and how they apply. We just are trying to give you some information about a type of leave you've certainly heard about, that we've gotten questions about, and how, as a general matter, that might work.
And I'd add one or two more caveats. One thing to be sure you do when you're doing an affected payroll is to talk at length, if you're using a payroll company, to speak with them and make sure they understand how this works, as well, since they'll be the ones actually controlling your deposit.
Now, Sage, what about if you are self-employed?
So these benefits do apply to people that are self-employed, but the mechanism for them to get the money is, of course, very different because they don't always process payroll tax in the same way. So for most self-employed persons, it'll be handled through their federal income tax estimated payments. So if they were spending $2,000 on leave, they would be able to reduce their estimated payment by $2,000. But again, we're awaiting guidance on the exact way this is going to work.
And now, Allie, I'm going to ask you a new program. I mean, I guess a lot of these are new programs, but an even newer program has just, there's been information about that, called the Paycheck Protection Program, or the PPP. Can you tell us about this program and how it's different from the tax credit program that Sage just mentioned?
Yes. So again, we're not tax advisors or accountants, but we want you to know, if you're an employer, that you have this benefit that has recently come out. You might have already heard about it, but for those of you who haven't, or who might have still not understand what it is, I'm just give you a quick overview of what it is. So essentially, the Paycheck Protection Program is the way that the federal government is giving what they're calling loans, but they really become grants that you don't have to pay back if you use them correctly. And you can use this as an employer to help cover the costs and keep yourself in business, because you might be needing to pay, for workers when they're not actually working, as we just explained, for family leave and for sick leave under FFCRA. It's just as a broad stroke how much money you would get. You would look at the last 12 months and take the average payroll for a month, multiply that by 2.5, and that's how much you can ask for from the federal government. And then you want to use that over 8 weeks to pay for your employees. And we're not going to go into the details, but there's specifics that you need to use it for. And then it becomes a grant.
Right. So it's designed as a loan, but in the end, if all the provisions are met, it more or less is that the loan is forgiven. So then it becomes almost a grant. Is that right?
Right, exactly. And I'll also say that it's meant for employers that have uncertainty, but most employers out there have uncertainty right now, considering these leave laws and not knowing who's going to need to take leave, etc.
So now on this slide, it notes that lenders may begin processing applications as soon as April 3rd. So that's Friday. Do you recommend that employers start looking into this now or what?
Yes, I think that even though April 3rd, which is just 2 days from now, is the date that they're saying they're going to start processing, I think everyone is probably going to be applying for it who can. So it's really good to get a jump start and communicate with your financial institution and get a plan in place so that you can have this as a benefit.
And to be clear, there are a lot of caveats that Ali mentioned and other ones. This is a lengthy program that could easily have its own webinar or several. So this is just a brief overview so that you know something that's available that could be very helpful. This program, Ali, can be used for all payroll, not just sick leave, but also could be used to pay the sick leave that we're talking about under FFCRA. Is that right?
Yeah, it's to be used whether you're paying while the employee is taking the sick leave, the paid sick leave, or while if the employee is actually still working because you're there's no stay-at-home order for you, or you're required to be in operation. It covers both.
So there are a lot of programs that are both new and old that are available to businesses, big and small, but we're really talking here about employers with less than 500 people. So we have listed on this PowerPoint, which again, we're going to email to you and will be available, just several programs that Katie Krakauka in our office has gathered and generated. And she has a lot more information on these programs on our website. We're listing them here for you so that you can look through them. Maybe this is a discussion for you to have with your counsel about many of the programs that we have. You'll see there's under small business, under the IRS, a lot of different opportunities for you to consider. And again, we're not going to get into all of these programs or really do anything else other than list them at this time, but we want you to be thinking about them, and really sort of take a breath and speak with your counsel and your other advisors as to which ones will be best appropriate for you and your circumstance. Okay. So we have a few questions already on our slide. Again, certainly can contact us and our team, as well as there's many others at Murray Plum & Murray who are able to answer questions. We want to get into some of the common questions that we got before the webinar, and then we'll be able to take your questions through the webinar. So one of the questions we get a lot is, do you have to pay leave at termination? So if we're talking about leave under FFCRA, so that's paid sick leave or paid expansive Family Medical Leave Act, the answer is no. If an employee is terminated or furloughed, they do not have to get paid. And I'm going to pause here to take a minute to talk about the difference between furlough and termination. There's no legal definition of furlough. Furlough we think of as my employee no longer works for me, but once a certain time period goes by, they are going to work for me again and they don't have to reapply. That is a perfectly appropriate colloquial way to think about furlough compared to termination. Termination is my employee no longer works for me and who knows what the future brings. Under these circumstances today with COVID-19, which are unheard of in our modern day world, those mean the same thing. So that person no longer works for you. You can bring them back if you want to, but you don't have to. And they are not entitled to FFCRA leave. In other words, leave under the Paid Leave Act that we've been talking about here. Are they entitled to other leave? That is paid time off that they might get, paid vacation. Maybe you provide paid sick leave. The answer to that, people love this when lawyers say this, is maybe. And that is because if you normally pay your employees their accrued vacation or PTO when they separate from your employment, then or that is in your handbook that says you will, then you should provide that at this time, whether your employee is furloughed or terminated or laid off. If you don't normally provide for that, which I think is a small minority of people, and your handbook doesn't say that you do, then you don't have to. That being said, one of the things that will come up is unemployment benefits. So employees who are furloughed or terminated or laid off, especially considering Governor Mills's amendments that have been in effect for some time, loosening some other requirements for unemployment benefits. Employees who get paid vacation or PTO, that is an offset to their unemployment benefits. In other words, if an employee separates and they would get unemployment, but they have 2 weeks accrued, that's 2 weeks of pay. That is usually an offset to their unemployment benefits. So you can, I would suggest do it in writing, not pay your employees potentially if you think you're going to bring them back and they and you want to keep those, vacation benefits, for example, in effect. So you're hoping you just had to furlough your employees for, 6 weeks, but you anticipate everybody coming back and they want to keep their PTO. They don't want to start at 0 when they come back. You can probably do that with their consent without paying their PTO because they want to get their unemployment. But you should speak to counsel about that because there may be circumstances where that is not advisable. And so, again, it's just important. There's so many moving pieces here. We get it. So the short answer is you do not have to pay any FFCRA leave. You probably do have to pay leave if you normally do that upon separation, but there may be a circumstance for an employee, for example, that you haven't officially terminated and have quote unquote furloughed, that you might be able to reach an agreement where you don't pay that employee their accrued time. The next question is, are employees' jobs protected? We talked about this earlier, but Allie, I'm going to ask you to take this one. Are employees who are furloughed or terminated or laid off, are their jobs protected?
Well, it kind of reiterates what you were just talking about. If they're furloughed and they're laid off, and they're not eligible for the paid sick leave and the family leave that we were just discussing, so they don't have any protections for their job under the law. So the answer would be no under a termination or furlough. But
if you want to, if you furloughed them or terminated them and then in 8 weeks they come back, I mean, is there anything that prevents you from putting them back in the same job at the same conditions?
no, and you probably want your employees to come back. I'm imagining that every employer wants all of their employees to come back and go back to normal. But this is just to make it clear that there's nothing that requires the employer to give that same employee the job back if that employee has been terminated or furloughed. Again, it's very different from if the employee is just getting paid leave.
And Sage, how about if that employee has taken that leave under either of these FFCRA statutes regulations that we're talking about?
Well, while they're taking leave, their job is protected, except for the exemption, the possible exemptions that their job, doesn't exist by the time they get back.
Another questions we have had frequently asked is, will employees be able to use FMLA after the FFCRA leave? So, Allie, can you tell us about that? And again, we have here one of those wonderful legal answers of, it depends. So.
I'll try to make it as clear as I can. So I think the easiest thing to start by asking is, are you an employer that FMLA already applies to? And if the FMLA doesn't already apply to you before this, then it's easy. You just have to look at the FFCRA law and you have to comply with FFCRA, full stop. We went over with sick leave and family leave, and you have to comply with that. If FMLA does apply to you and did apply to you before this law went into effect, then it's a little bit more complicated in terms of family leave. So for sick leave, you can put that aside and understand, yeah, I have to pay sick leave. But for the paid family leave, you still have to comply with it, but you have FMLA there as well. So think about it as, 12 weeks of FMLA, and the FCRA part of it, the paid family leave part of it, is a part of those 12 weeks. So
I suppose you have an employee who in January of this year, pre-COVID-19, and again, we're looking at your example here, took 2 weeks off and used under FMLA because they had surgery. And now it's April 1st, and so they're eligible for family leave, and now they need to take family leave to care for their child whose school is closed. How are they eligible for the 12 weeks under the FCRA Act?
Right. So in this example, again, we're talking about family leave because of childcare. We're not talking about sick leave. And just want to again make that distinction. And because this particular employee in this example has already taken 2 weeks within the 12 months, then there's only 10 weeks left because they already took those 2 weeks under FMLA. So in that example, that employee would only get the 10 weeks left for paid family leave.
And the same could be true for an employee that took a lot. So if you have an employee that has already used up, say 11 weeks because, they were on maternity leave or because they had a lengthy surgery, again, that employee would still only be eligible for, in that example, an additional week under the emergency provision. Is that right?
Yeah, that's correct. And I'll add that if there's any confusion here, because it is confusing, feel free to reach out to Employment Counsel. They can help you understand what you need to do.
Right, because there may be other, and again, we've talked about previously, there may be other reasons that you want to provide unpaid leave, or even paid leave, depending on your circumstances. But under these statutes, the employee it isn't double counted. They're not eligible for 12 weeks of their regular FMLA and 12 weeks under FCRA.
Yeah, and I'll also add to that, you won't get reimbursed by the government if you don't follow it all to a T. So even if you want to be giving the employee more and paying that employee, this is important to understand what you won't be able to get back.
Right, good point. So Sage, tell us about employees under stay-at-home shelter-in-place orders. So this is something we were going to talk about anyway, and then it has become extremely relevant since Governor Mills's decision yesterday to issue the statewide mandate, basically putting the state under a shelter-at-home provision, except for essential employers. So tell us how that works.
So yes, it is a qualifying event if the employee cannot telework. So at this point, unless your business is part of is deemed essential by the government, chances are you're shut down, and unless your employees are able to telework. So yes, this qualifies as being under a stay-at-home order, and your employees can apply for sick leave.
And so we've talked about teleworking a lot. Can you talk a little bit more about teleworking? I mean, we're all doing that now here on this webinar. You can all see that we're, not in the office, but at our houses. How does that work? Can an employer just say to any employee, yeah, go ahead, you can telework?
Well, I mean, there is the reality that some types of jobs just cannot be done telephonically or from home over the internet. And the employer then has some discretion as to whether or not they want to redefine that person's workload. They certainly can try and try to come up with an arrangement where the employee can continue to work remotely. But that in many cases won't be possible. For example, if you're a day laborer on a construction project that's been shut down, chances are the employer isn't going to be able to reassign them to do office work.
Right.
So that person would be considered, it would be one of the first 3 reasons for applying for sick leave, and it would allow them to apply at the higher rate. But
and Allie, what about if, go ahead, Sage, sorry.
No, go ahead.
Yeah. I was just going to say, Allie, what about if a person is able to, or an employer is able to switch sort of positions, job duties, and an employee can telework for, 35% of their day or their week, but not the rest? Is there, do the intermittent leave provisions still count?
Yeah, the intermittent leave provisions would count. You are able to take intermittent leave if you cannot do all of your job duties and you're only doing a percentage from home, from teleworking. You can do that. But again, I was just thinking about how the paid sick leave, of course, is limited to 2 weeks if you're a full-time employee. And this stay-at-home order might go in, it might go into effect longer than 2 weeks, as we've seen. It's already been that. And so I think I just want to also mention it's important for employers to communicate in writing with their employees, to let them know that there's still an operation, and because the employee might not get paid after those 2 weeks, even though they still can't work. And I think that's an important distinction too, but the employer is still operating. So be very clear about if you're closed or if you're operating still.
And that was Sage, something I was going to ask you next is, what happens if you have to close your business due to this, order or other reasons related to COVID-19?
Well, if your business can't operate, your business can't operate. And if you're not operating, chances are you have terminated or furloughed your employees, and they are thus not eligible for these benefits. So you wouldn't have to provide them. There are other government programs in the works, some of which have similar names or phrasing. So it can be very confusing. For example, there's a payroll tax credit that's available for businesses that retain their employees despite being closed. But that's not part of FFCRA.
Okay, so if you close your business, one of the things we do recommend is that you make that clear to your employees. And again, we recognize this is fast moving. Governor Mills just announced that yesterday, and it goes into effect at midnight. So we just do recommend that you just make that clear to your employees. Are they still open? Are you still open? Or are they considered terminated and furloughed? It's also really important for your employees, A, so they know, but B, so that they can begin to collect unemployment. If employees are furloughed or terminated, they can begin to collect unemployment. And again, Governor Mills, as I said, has modified some of the unemployment provisions that might otherwise apply. So employees are eligible for unemployment if they are put down on a reduced schedule. So under this example, suppose you have 2 days a week of work for your employee who previously worked 5 days a week, but that's just all you have due to your business being closing. That employee likely is eligible for unemployment, for the equivalent of 3 days a week, or 3/5 of what they might otherwise be eligible for. I have had a lot of questions that on unemployment and employers who think that their employees should be eligible and who sound like their employees should be eligible are getting turned down for unemployment. My best guess is that is because these unemployment laws are so new and so different from the unemployment laws that have been in effect, prior to this. And so I think it is just a confusion on that end. I appreciate that me suggesting to call the unemployment office or email them is not very helpful because those offices are flooded. But your employees should be eligible for unemployment if they are furloughed, terminated, laid off, and including on a reduced schedule, and the provisions that were previously in place that required employees to be employed for so many months before they were eligible have been eliminated, as far as my understanding is, based on Governor Mills' modifications. I have heard that is not always translating to the practice of your employees. My best advice there is that you encourage your employees to continue to try to get the benefits. I think this is just such a fast-moving change. So, it's difficult, but that's the way that employees are going to have to proceed.
So I'm just going to jump in quickly. I saw in a chat there was a question about what is this law called and what's the acronym, just a reminder. So the big law that we are talking about in this webinar is the Family First Coronavirus Response Act. It was signed into law by President Trump on the 18th of March, and it goes into effect today, and it stops being in effect on December 31st, 2020. And again, it has two parts of it, family leave and sick leave. So just for those of you who might not have caught the beginning, I wanted to make that clear for that question.
Thanks, Allie. And that is commonly referred to as FFCRA, family. And then underneath FFCRA is the Expanded Family Medical Leave Act and the Emergency Paid Sick Leave Act. Those are parts of FFCRA. So thanks, Allie, for fielding that question. So the next question we have prepared is overtime included when calculating pay? So Sage, can you answer this one?
So it is included, but in a somewhat odd way. Remember earlier when we talked about how you would be paying these benefits based around the employee's usual schedule or expected schedule. So if you have an employee that regularly works overtime, that gets factored in that way. So if they're taking sick leave and they normally work 50 hours with 10 hours of overtime and 40 normal hours, then the way you would calculate their sick leave pay up to the maximum, of course, would be that 40 hours at their regular rate and 10 hours at their overtime rate for the first week. And then in the second week, all they'd have left would be the 30 hours remaining at the regular rate.
And going back previously to what Ali talked about, Sage, this is calculated based on either the 6-month average, if the employees have worked for at least 6 months, or the average of what they have worked, if they haven't worked for 6 months, or if there's an agreed upon schedule, right?
Exactly. And the order of preference there is agreed upon schedule and then the average based on either the last 6 months or whatever available work history there is.
And there's another question, Stacy, about the WorkShare
Yeah.
program. There's a question from Jackie. Hi, Jackie, saying, is the WorkShare program, which is half work and half unemployment, part of FFCRA?
Well, that's a good question. And the answer is it's not, well, it's not technically part of FFCRA. FFCRA does allow for intermittent leave. So in that sense, it could be part of FFCRA. In other words, you can allow your employees to, if they're working, if they're teleworking, either under the sick leave or the family leave provision, to work a portion of their day or their week and then take another portion under the FFCRA Leave Act. That is separate from unemployment, which does allow for, at least now as modified, our understanding is it does allow for employees to work a portion of their schedule and then collect unemployment for the other portion because, you know, their days, their hours, their duties are substantially reduced. So there's some overlap, at least in terms of how they are described, but FFCRA is not unemployment because under FFCRA provision, your employees are still your employees and you're still in operation.
Great. And we have 2 other questions I'll just throw out that we got from the people listening. One of them, I think we've already answered, but I'll go over it again. The question is, the first 2 weeks of FMLA unpaid and the employee uses the 2/3 pay at regular rate, can the employee also supplement their PTO to pay the remaining 1/3? And I'll just take that and say, so just to not confuse people, the first 2 weeks are unpaid, and so unless the other pay that has the other leave that has been accumulated potentially, you know, is used at the election of the employee, then that would just be unpaid those first 2 weeks. And in terms of the paid portion of it, for family medical leave expansion, the last 10 weeks, yes, I talked about you can supplement that to get 100%, but it has to be, the employer has to agree to that. The employer has to say that's okay.
And to clarify, those first 2 weeks, as we've said, if you're taking leave for child-related reasons, which is why you're allowed to take leave under the Expanded Family Medical Leave Act, that is also qualifying condition number 5 under the Paid Sick Leave Act. And so those employees could get paid for those 2 weeks. That is still at the 2/3 rate. So, and yes, the same, as Ali said, decision applies that you can let the employee, as the employer can either supplement that 1/3 rate, you can let the employee take accrued leave that he or she has already accrued to supplement that 1/3. And we keep saying 1/3, keep in mind that it's a $200 maximum. So it may be that they would get a lot more than 1/3 depending on their rate. And you don't have, so just know that we're saying 1/3 here, but really it's the $200 maximum regardless of the 2/3 rate.
Yeah, that's a really good point.
The thing to keep in mind though is that for reimbursement, or I should say reimbursement, but for your payroll credits, you don't get reimbursed or otherwise from the government for the portion that you, the employer, are choosing to pay. You might be able to use the PPP program or other programs to get that money, but it's not going to, you can't get tax payroll credits.
Right, and the last question I have here on this list is it's a really good question. It says the employee has 2 qualifying reasons for paid sick leave. One of them is that they have to self-quarantine, and the second one is that they have to stay home because of the daycare. Can they receive both the sick pay 100% and the 2/3 pay? And well, I'll let you answer that, Stacy.
Well, that's a good question. So the leaves don't overlap. So if they are taking that paid sick leave, they could get that at 100% of their rate because they themselves, as I understand the question, they themselves are sick and under quarantine. The remainder 2/3 pay. Well, that's basically they have to elect that. That is for family leave. So if they want to get paid additional because they have to, if they're caring for a child, they could be eligible for the family leave. But when it comes to the sick pay for themselves, they're eligible for 100% up to, if they're a full-time employee for 2 weeks, up to 80 hours.
Right. Essentially, you have to choose one on the list. You can't choose more than one.
Right. And it's a good question. Yeah. It's a very good question because there's those 6 qualifying reasons, right? And people, but you could see a scenario where they could qualify for all 6, right? We're under COVID-19 orders. People could be sick. They could be caring for a sick person. So, right, they don't get to stack on the different qualifying conditions for leave. They do get to get, if they qualify, paid leave and expanded medical leave. And of course, presumably employees will seek to do the 100%. However, as I just mentioned, with the $200 maximum, when you get paid 100% of your daily rate, that is also up to a maximum of $511. God forbid this be a round number.
Right.
So if your employee normally gets paid more than that amount, again, that is something that you on your own, the employer and the employee could discuss if they had accrued leave that could supplement that, but that is outside of FFCRA.
Yeah. The last thing I'll say before you move on, Stacey, is somebody wrote in with a specific fact pattern applicable to them and wants to know whether or not they can fall under one of the categories. And we can't do that analysis here. It's a case-by-case basis. So I would say that if you have specific questions for your situation that are fact-specific, that you should reach out to one of us afterwards and see if we can help you on an individual basis to figure out how you might be able to get these benefits.
And it is certainly, that's really good advice in general. This is the overview. This hopefully applies to most people. But if there's going to be certain employees, certain situations that really still require more in-depth analysis, and so we definitely advise you to reach out to counsel to get those answers to those questions. So I'll just go through our slides and we're almost done here. Feel free to submit more questions, but the next slide we have prepared is just how is a part-time employee defined? Allie, do you want to take this one?
Sure, yes. So a part-time employee is defined as somebody who works less than 40 hours per week. So if you have an employee that works normally 39.5 hours every week, then that employee would be considered part-time. And again, we talked about how part-time employees can only take the number of hours that they work in a 2-week period, and that's how much sick leave that they get under the Act.
Okay. And right, so again, for the FFCRA Acts, part-time employees are employees who work less than 40 hours a week. So an employee who works 39 hours a week is considered part-time under FFCRA. But unlike other provisions where that might have a more significant application, this just means how many hours of paid sick leave that employee is entitled to. So if he only works 39 hours, he's only going to be entitled to 39 hours over 2 weeks. So 78 hours total as opposed to 80 hours total.
Right.
Okay. And I think this is our last prepared slide. Sage, do employees still receive benefits while on paid sick leave?
Yes, they do. They should still receive the normal benefits you provide for them because they are just on sick leave and subject to the protections we talked about earlier. This particularly includes healthcare benefits.
So, Allie, have any more questions come in on the line that we should be getting to?
Let's see. I am looking at the list here.
Okay.
All right, we have a question that says, is there any way to confirm that you are an essential business?
Oh yeah, that's a good question. And we were just talking about that before the before the webinar between the three of us. Governor Mills, when she first issued closure orders, she did define essential businesses. Most recently, she hasn't updated, I guess, that definition. And for some businesses, for example, construction, there is some debate as to whether her previous definition applies or sort of this current definition applies. So, but there is a formula, and you can go online to find it, about in terms of regulations that have been submitted by Governor Mills about which businesses are considered essential businesses. Hallie or Sage, do you want to say more on that?
Well, I was just poking around briefly on that, and it does look like the state has put out a list now. It's not 100% clear for all types of businesses, but it is more clear than the previous guidance. And I'll see that list is included with the PowerPoint slides when they get mailed out.
Great, thanks. Yeah, and that's another thing where, right, there's certainly there's still going to be some confusion with certain potentially businesses or positions, and so, you know, feel free to reach out to us or some other person if you need some clarification on that. But like anything, I think there's going to be a bit of confusion certainly with some industries.
Yeah. Okay. So another question is it in this? I'm not exactly. I don't know if I'm getting this question right, but I'll do my best. Is it okay for a child care center to pay for 40 hours per week for teachers while they only have 32 hours due to their lower numbers? So that question is unclear whether the 32 hours are their normally worked hours and this employer wants to pay them 40, or whether or not you know, that only became 32 hours a week after this crisis.
So again, you have, when it comes to the average number that employees work, you have to look at the 6 months, you know, the average of the 6 months prior, or any agreed upon schedule. And as Sage has said repeatedly, it's the agreed upon schedule that really predominates. So if that employee normally only works 32 hours and that's the agreed upon schedule, then that's what they get. I understand potentially the question could be saying, look, this person normally worked 40 hours, but you know, more recently only worked 32 because of closures or something like that. Again, if that's the case, you need to look at that average over the 6 month period. But you only have to pay the employee the hours that employee worked on an average. Under FFCRA, you're welcome to pay that employee more, you know, up to 40 hours, but again, you're not going to get reimbursed from the government for that time. So hopefully that's answered your question. If it hasn't, certainly reach out to us afterwards.
Yes. All right. The next is a question that relates to how sick leave and family leave interact. And so the question is, for reason number 5, an employee could take the 2 weeks of paid sick leave at 2/3 pay, then 2 weeks of unpaid. Family leave could supplement with PTO, and then remaining 10 weeks of family leave at 2/3 pay for a total of 14 weeks, combining paid leave and sick leave. Correct. So I think this question is it possible to get 14 weeks of paid leave?
Yes, you have that right, Jessica. Yeah. Well,
it's not 14 of paid. It's only
paid,
12 of paid. But yeah.
Right. It's 2 weeks of, it would be 2 weeks of sick, and then 10 weeks of family medical leave would be 12 weeks of paid. The 14 weeks, there would be 2 weeks in there that would be unpaid.
But by unpaid, we mean unpaid by FFCRA.
Correct.
It looks in that question like the employee was going to draw on PTO for that 2 of those weeks. And yeah, if your employees have PTO they can draw on, that is separate from what FFCRA will pay for and can be used to supplement
Right.
as we think.
Yeah, I think you're right, Sage. I think that was the best interpretation. So this question was, you can get 2/3, 2 weeks at 2/3 pay. You could then take 2 weeks unpaid by expanded medical leave, but paid by accrued PTO. And then you can get 10 weeks of expanded family medical leave at 2/3 pay again. So that's a total of 14 weeks combining paid sick, PTO, and FFCRA leaves. Again, and you can be as creative as you want, or as you know, with your employees. And you know, it's a moving piece, and that's a lot of times why you have to look at each individual individually, but at the same time, again, always keeping in mind that you want to make sure what you're doing with one employee, you are doing with all to the extent that it is possible. All right, it looks like that's all the questions we have, which is really good timing. Oh, we have another one, Allie?
Yeah, sorry, I thought that you were saying it. Yeah, so the other, oh yeah, the timing, well, we have a few more minutes. So another question is, if an employee uses all the paid benefits through FFCRA and all accrued paid time from the company and can't work or telework and has a qualified reason to be out of work, can they apply for unemployment?
That's a good question. Yes, I mean, if they can't work or telework, then you can decide they can qualify for unemployment. So that is one of the provisions that has been modified by the unemployment statutes. In other words, they're not able to work. It's up to you, really, if that person's going to be considered on unpaid leave status, they may need to be furloughed by you in order to qualify for that unemployment. Normally, a person who's employed but on unpaid leave status doesn't qualify. Governor Mills has modified many of the unemployment provisions. It's not totally clear if that one's modified or not. And so that's just a discussion you should have with your employee, and we can see if there's been clarification at that time. Appreciating that time could be now if this is an employee we're talking about who has used up a lot of his or her leave already. So I know that's kind of a vague answer to that, but there's a lot of vague
There's a lot of vagueness right now, yeah.
Questions right now.
Yeah. And this one, Stacy, goes to something you were talking about earlier in terms of furlough and people that want to save their accrued time that they've already had for, over the past year, and they want to use it again after the furlough is over. The person asks, is there a form to have employees fill out to have the employer hold their PTO time until their furlough is over?
There aren't any forms like that, at least as of now. Again, I think that is a great thing if you as an employer want to have that discussion. Certainly, I think you're going to want to get that in writing. And that's something that really hasn't been defined or regulated yet, either at the state or the federal level. In other words, that is whether you can save PTO that you might otherwise have distributed to the employee. So you're just going to want to get that in writing. There's certainly benefits to the employee for doing that. And if the employer and the employee both have every reason to think that employee will be coming back after 6 weeks, 8 weeks, then they certainly might want to save that leave. So get that in writing. There's no form, there's no magic words, at least as of yet. Just be as clear as possible. And that may be something you want to reach out to counsel to discuss before you do it.
Yeah, an attorney can help you have a form. Sage?
It's also just from a practical business standpoint, something to be just to really think through. If there is a real possibility that the business won't survive, then this potentially puts the folks involved in a difficult situation where they've given up a benefit that they are owed that will not ever be able to be paid because they will never be coming back to be employed. So there is risk involved, and everybody should be aware of it.
Right. Right. Yeah, go ahead, Allie.
Yeah, it sort of goes into the next question a little bit. What if a company lays people off before the order anticipate? I'm not sure what order exactly is being referred to, but before the executive order, anticipating an order to close. So I think the question's referring to stay-at-home order by the governor. Then do the employees all lose the health coverage because they are laid off rather than that they left on family or sick leave?
I guess I'm not totally sure I understand the question. If you laid off your employees prior to the order, then they would be completely laid off and not entitled to healthcare benefits. Some employers have been using the word furlough, as we've said, there's no legal definition for that, to have their employees no longer work and be eligible for unemployment, but employers are on their own still paying for healthcare benefits. There are some issues.
Sorry, go ahead.
There are some issues there that we're hoping, will be expanded upon. In other words, some healthcare insurance require employees to be working to be eligible for their healthcare. Again, we're hoping that the state and federal government will come out with some more regulations on that piece. But if employees were laid off before either today or Janet Mills's order yesterday, then they are laid off.
All right, and a follow-up to that is, let's say that the employer laid off 5 employees before the stay-at-home order came out, and then decides that they want to take them back, or have them work. Let's say that they say you're laid off, and then somehow they hire them back. Then after that, can they then pay them the sick leave and the family leave? So can you hire somebody back and then pay the sick?
Oh, I see. That's the question. Yes, there's nothing that would prevent you from doing that. And I think absolutely. And actually, I think that's a lot of what these, it took a while. I mean, it happened quick, but also took a while for these provisions to come out. I think a lot of people did have to lay people off in the interim, not knowing that there was the PPP, not knowing that there was, tax credit involved. But yes, I think if you had a layoff or a furlough, you would have to bring those people back on board, but then you could give them the Sick and Family Leave Act, to which they're entitled to, and potentially use, not potentially, you could use the payroll tax program we talked about, and then potentially use the PPP program to help pay for that. So absolutely, yep, there's nothing that prevents you from hiring people back, even if it means that they're then all of a sudden, once they're hired back, if they qualify, they're going to be eligible for these leave programs.
Yeah, I think that's what the question is getting at. And again, just to reiterate what you said, that's the reason why the government did this, because they realized that people were having to fire employees. They didn't want them to do that. So if you've done that, you can hire your people right back, and then you can pay them this leave. One of the people said that they want this to be shared with their employees and supervisors, and they want the audio of this PowerPoint presentation in addition to the slides. Yes, we will have the whole recording of this PowerPoint available for people to share with whoever they would like.
All right, so that wraps up. We are past the 1:30 mark. I know there are so many more questions that need to be answered, and tons of specifics. Again, this was designed to give an overview, as well as answer some of the more commonly asked questions. We're going to be emailing this PowerPoint to everybody who's registered. We'll have it on our website, where the video is recorded and will be available on our website and on YouTube. And again, we are available for consultation should you need us. Good luck, stay safe, everyone, and do the best that you can do with these challenging times. And thank you for joining us. And have a great day and rest of your week.
Thank you, guys.